Hey everyone, ladies and gentlemen, esteemed members of the Planning Board and valued community representatives. I welcome you all to this evening's assembly of the Saco Planning Board. As chairman, it is my privilege to convene this gathering dedicated to the thoughtful planning and development of our community. Today we come together with a shared commitment to shaping the future of our city in a manner that reflects our values, respects our heritage, and fulfills the needs of our residents both now and in the future. This evening we have our yearly training, and we have some staff members with us to go through some of their process during the review period as well. So with that, we will call to order the August 11th, 2026 Saco Planning Board to order. Look forward to the productive discussions and meaningful outcomes that lie ahead. Thank you. With us this evening, we have myself, Matt Provenzel, the chair of the board, and to my left, our Vice Chair, Joyce Leary-Clark, and Planning Board members Jeff Brochu and Catherine Palini, and to my right, Planning Board member Jim Mollier. Our staff members from the Planning Department this evening with us are Lauren Forte, Madison Vlass, and as always, Lisa Harmon, our Planning Compliance Manager. Along with lots of folks from city staff that will be, you can introduce yourself here in a moment. But with that, we will we'll move to our first item on our agenda real briefly here, which is our review of our previous meeting minutes. Do board members have any question, comments, or edits on that?
Mr. Chair, I would move that we adopt the July 21st, 2026 meeting minutes as drafted.
Thank you for the motion, Jeff.
I'll second.
Second by Joyce, thank you. Any additional discussion on the motion to adopt the minutes as drafted? All right, those in favor, Jim?
Yes.
Joyce?
Yes.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes as well. Motion passes 5-0. Continuing along, our after the fact packet this evening, we don't have any. We do have some general correspondences that we
Mr. Chair,
can address. Jeff?
if I may, I did not make a motion on the site walk minutes.
Oh, I'm sorry.
So, if
Nope. Please continue. I thought
well,
I heard all the minutes.
if nobody had any corrections,
Yeah.
I want to thank staff. They're very thorough and really captured the event, the meeting. So with that, I would move that we accept the 995 Portland Road site walk meeting, site walk minutes from July 22nd, 2026 as drafted.
Second.
Thank you for the motion, Jeff, and the second, Jim. Any additional discussion? All right, those in favor, Jim?
Yes.
Joyce?
I'll abstain. I wasn't there.
Jeff?
Yes.
Catherine?
Yes.
I'll vote yes as well. Motion passes 4-0 with one abstention. Thank you for the clarity. I thought I heard minutes and grouped them together. So our next item, 5 on our agenda this evening, after the fact packet. We don't have any after the fact packet this evening. Our next item 6, our consent calendar items. We don't have any consent calendar items this evening. And then item 7, our planning board public hearing guidelines. This is a document developed by the board and city staff outlining the procedures in place for our public hearings held. This explains the purpose of a public hearings, the outline procedure of reviewing an application, public comment, presentation, and meeting duration. This is a document that we have available online and at the rear of the auditorium. If anyone has any questions, please let us know and we'll do our best to answer those for you. Our next item on our agenda this evening is our public comment period. Our public comment period is an opportunity to hear from members of the public. We limit the item to a total of 15 minutes, and this is for items or topics not under planning board review. The planning board appreciates public comment and recognizes that public comment about matters before it can help the board understand neighborhood concerns, review an application, or help understand additional items. Those wishing to make statements about an application currently under review are asked to provide those statements during the applicable public hearing period. Comments are limited to 3 minutes per person. However, if there are multiple members looking to speak, we may reduce that time to accommodate all speakers. So with that, if anyone is with us this evening that would like to come to the podium and address the board with any general planning items, please feel free to do so. All right, seeing no participation this evening, we will continue along with our agenda. Our next item, number 9, is our planning board training, and I believe we have Phil Saucier here from Bernstein Shore that will begin, and we'll follow. I think Emily has some staff members here to introduce us to, and we'll take it from there. So with that, Mr. Saucier, take it away.
It's nice to see everyone again. Thanks for having me back. This may be, I'm seeing very familiar faces. So some of you have seen my training a couple times at this point. So I may actually kind of not go over everything in as much detail, just seeing. And Catherine, I can't remember if you had this training before. Okay, so this is old hat for everybody. Interrupt me, ask questions. That might be more interesting for you. I'm not going to go over every single thing that I usually do, given the fact that you guys have all been through this before. But there's a few things that are worth going over just as a refresher. And one of them is Freedom of Access Act. Again, I'm not going to spend a ton of time on this again because you guys have been trained in it. But just as a reminder, it's always good to be reminded of the Freedom of Access Act. That's main sort of sunshine law or open access law. The intent is that your meetings are held openly and your documents are open to public inspection. If ever challenged, the court will construe that law liberally, meaning sort of on the side of disclosure. Again, it covers 2 different sort of topics or areas: public meetings, like we are in today, and public records, like the documents sitting in front of you. Public meetings are the transaction of any functions of any board in this town, essentially, to boil it down. It's essentially almost every public entity, with some limited exceptions, but for our case here, we're talking about municipal boards, including planning boards. Our meetings are open to the public. Someone could walk in, obviously, today. There are some limited exceptions, and those are executive sessions. Your planning boards sometimes have executive sessions, but rarely. And the only, to go into executive session, you have to fall within one of the exemptions that are in the statute, and you have to cite to that exemption, or to that exception. The only one that I can think of that typically planning boards will use from time to time is consultations with legal counsel regarding your legal rights and responsibilities. So every once in a while you'll have that, not often, because you've been here long enough that actually a lot of times the legal advice you get is actually in public, and there's good reasons for that. Your city attorney's interpretation of an ordinance or things like that, and there are some limited reasons why you may want to have an executive session, but otherwise it's actually good, I think, from my perspective, for people to hear how the city attorney is interpreting something. It does not prohibit communications outside of the meeting unless it's used to defeat those purposes. What that really means is you can talk amongst yourselves and on non-board related matters or non-substantive matters, but what you shouldn't be doing is talking about the applications that are in front of you, any kind of pending proceeding. That has to happen in the meeting. There are very good reasons for that. There are due process considerations. The applicant has the right to understand what kind of information you have when you're reviewing the application, and so that they can provide alternative information or questions or rebut that kind of information. There must be a record of this proceeding. It has to, this is what's typically, you guys just did minutes. Minutes are actually not required under Maine law, but what is required is a record, a very basic record. The time, date, and place of the hearing, who was there of the members, and how the motions were taken in the votes. Audio and video, does qualify for that FOA requirement. But again, oftentimes boards have minutes. You go into a little bit more detail. It's helpful for people to understand the topics if you want to go back through minutes and see what people were talking about. Again, people have the right to attend. They can film and tape you. You may have seen that before. They have the right to do that as long as they're not interfering with your business. They can tape this meeting. I already went over executive sessions. Again, it can only be for those specific provisions. You have to cite the statute. It has to be a 3/5 vote to go into executive session, and you can only discuss those matters. Finally, importantly, you can't vote in an executive session. So you can only discuss the specific matter that you're allowed to go into executive session for, and then you would take any vote outside of the meeting. Typically, again, these are usually used by your city council. So labor negotiations, real estate disposition, employment-related, personnel-related matters, and then, of course, legal consultation. Those are the sort of the ones you'll see more often. Also, economic development. So you may see some TIF proposals and things like that start an executive session. That's allowed as well. So notice, your local ordinances sometimes have more specific requirements, but all that's required under FOA is that the notice must be given an ample amount of time to allow the public to attend and disseminated in a manner reasonably calculated to notify the general public about the meeting, essentially. And you can have an emergency meeting, and you can, as long as you get the notice out to members of the newspaper industry. Decisions. Now, this is important. I'll get into this a little bit later, too, but there's a Freedom of Access Act requirement for decisions, which every agency must make a written decision involving the conditional approval or denial of any application, setting forth your reasons. That's so people sufficiently understand. It's interesting it doesn't include approvals, but we just add that into. It should be a written decision for any reason, and that's for different reasons, for review by the court and for the applicant to understand your decision. So there really needs to be written decisions. I know you guys do that. You do a good job with it. You've got very qualified staff to help you with that as well. But making written decisions under each of the factors that you're going to review, so that if ever having to be reviewed by court, there'd be sufficient evidence in the record to support your decision. Remote meeting participation. This is a product of COVID. Before COVID, remote meetings were not permitted in Maine, but with some limited exceptions again, some agencies. But now, as you all know, you can have remote meetings as long as your city has a policy that governs it. If a board member participates via remote participation, you have to open up remote participation for members of the public as well. And there are some other rules here. I know that the city has some sort of policy. I'm not the general city attorney, so I wouldn't have worked on that, but you have to show how people can log in. The materials must be available. But importantly, it really, I think in my, just having a little commentary, it did provide a nice tool for certain times for quorum purposes. For example, that was one of the issues before COVID, is you were not allowed to, a board member could call in and watch, but they could not vote, and they couldn't be counted for quorum purposes. Now you can, as long as you're following the policy, if you're participating remotely. I think I've gone all over that. So that's public meetings. Public records are the documents, but it's not only documents these days, it's mostly electronic documents, quite frankly. Text messages, anything of any kind of mechanical or electronic information in your possession or in the possession of a government official that's received, prepared, or containing information related to the transaction of public business. So again, it's not every document that you guys have, your personal documents. Just because you're a board member doesn't open up your life. Some people may ask for it, and I see that sometimes, but that doesn't mean it's a public document. Public documents are the documents related to your work for the city. Yep, stopping me there.
So just with that, like, we've been through several times, like the notes that, I like to keep notes of like the votes and who was for and not. How does that work? Because it seems like with, the FOIA request, the city staff is usually the one that's compiling all that stuff. So somebody would make the request to city staff, and if they said, hey, specifically we want to see the notes that, the board's taking, would then city staff reach out to us and ask us to submit our paper copies?
Yes, that is typically how it works. So, okay. And I'll jump ahead a little bit, but every municipality has to have something called a public access officer. So it's essentially the point person for FOA. It's often the city manager, administrator, or the clerk, or some other official like that. And their job is to coordinate those responses. And so one of the sort of best practices, I would say, is nowadays you see more and more IT retrieval services. So that's without even having to ask anyone, they can go in, at least on the city-owned accounts, and they can do a search for any certain words. But then you should really take it one step further and send an inquiry through email or something else to say, we received this FOA request. Do you have anything in your personal possession? So any documents like that. And if so, that relate to this. If so, give it to the FOA public access officer. So yes, in that case, you should do that. And then that's really on you to determine that, right? Because the city doesn't have access to your personal documents and things like that. So each board member would then determine if they have those kind of information, if you ever get that kind of request. Yeah.
Just shut it off. I mean, does that mean we take notes, we have to keep our notes?
So
And for how long if we do?
So that's a different statute. So the main archives, which is a division of the Secretary of State's office, publishes a records retention schedule. And they have a specific one that relates to municipalities. And it's fairly detailed. The types of notes, drafts, permits, all the different things. They each have their own schedule. I think sort of, and this is off the top of my head, so you have to go back and look. I don't have that one. But there is a time limit on just notes that are not related, like your personal notes. I would say for some reason 6 months is coming to mind. Certainly, what we would recommend, even if you don't, is at least past the appeal period. So you vote, 30 days goes by, there's no appeal. At that point, again, I'd want to make sure, but you either just keep them in a pile. That's what I did. I was a board member for many years and on a couple different boards, and I would just keep them in a pile. After a certain number of years, sometimes I'd give them back, depending on I worked boards in 2 different towns. One town I worked in took our notes at the end of our meeting. And so that was actually easy for me as a board member. I just take them. You deal with them. I don't know what they were doing with them, but they were putting them away. The other town I was a recent board member in, it was sort of, I had to keep my own documents. And so after, I think, just a couple of years, I would feel like you could throw them away.
Thanks.
Related, we get a lot of paperwork sort of like after the fact packet stuff, or as site walks, we get plans. If we don't make physical notes on them, like if it's just what we're handed and we're not changing or adding our own notes to it, do we need to keep that?
Yeah, oftentimes copies can be discarded. So if you haven't notated it or anything like that, if it's
Because they all come
if it's a
through-
duplication of something.
Yeah, they all come through the office and are handed to us,
Right.
so,
That's
okay.
right. So those can
perfect.
often be recycled, again, as long as there's no notes on there, because you may have written something on there that someone
Yeah.
wants to see. Right?
Okay.
So that's a little different.
Okay, perfect, thank you.
Yeah. So just for purpose of the training, I'll just mention really quickly, there are exceptions, just like on public meetings where we have executive sessions, there are exceptions to public documents. You see a list up there. Some of them are fairly straightforward. So obviously like information like Social Security information, financial information that may be in a communication, certain medical history information that may be in an where with the sort of more complicated ones that we get are various police department records. So the Investigations Act and the Criminal History Record Act, both the police department is very aware of it. We get questions. Takes a lot of time to sort through those questions. And then the other area that we get a lot of questions about are personnel-related records and what can be released and what can't be released. But the legislature continues to tweak this. So every session, there is a ongoing committee in the law that actually is set up. It's an ongoing committee that reviews Freedom of Access Act law, exceptions, that sort of thing, and routinely makes recommendations to the legislature's Judiciary Committee to review. So you'll just see every session, there will be some sort of tweak to the Freedom of Access Act, so you have to sort of stay on top of it. Anyone can make a request. Again, you won't be dealing with this as much. This will come through the administrative office, but this is the way it works. Anyone can make a request. The city, they don't have to answer at least why they're making it. It doesn't have to be in writing, although you can request that it be in writing. It's sort of easier just to process if it's in writing. It has to be acknowledged within 5 working days. The city has to provide an estimated time and cost within a reasonable amount of time. The city would then locate the responsive records, redact exempt information, and then provide a time. That cost is also regulated, so the city can only charge $25 an hour after the first 2 hours of staff time that's spent, so that's in that estimate. If the costs are greater than $50, you have to notify them before proceeding. If it's greater than $100, you can require payment in advance, and that's, I think, I've seen cities start to do that more and more with the volume of FOA requests. So you can say, whatever the estimate is, we'll begin once you receive a check for that. And then again, you can also require a check for it at the end of the process too. So if you didn't ask for it ahead of time, you can ask for payment before you hand over the documents. And there are fee waiver requests. I don't see them granted very often, but it's for indigency or in the public interest. Violations. So there can be appeals of FOA decisions, both, quote, illegal meetings or refusal to turn over certain documents to Superior Court. The burden is on the city to prove what they did complied. So the consequence of an illegal meeting is that the court could void the decisions that were made, the contract that was awarded, the approval that was granted. There could also be subject to penalties and attorney's fees for that process. And then there could be a willful violation penalty of more than $500 if you did something willfully. I already mentioned this. There is a public access officer requirement in every municipality to coordinate these issues, and there's also a public access ombudsman who sits in the Attorney General's office. Brenda Keelty is her name, and she's been doing it a long time, and her job is to coordinate any responses. I sometimes hear from Brenda in my role as a town attorney, because people will write to the ombudsman with concerns, and then she'll help coordinate responses. Training, so this is what you're getting right now. Certain public officials are required to be trained in FOA within 120 days after they take their oath of office. That includes planning board members. That was added just a few years ago. Again, the legislature continues to add to this list, I find. So these are the people who need to be trained. I think it's good for anyone who works in municipal government to be trained in this. Yeah, it's interesting to me that like planning board members but not zoning board members, it's sort of random. But they called you guys out at some point. And I've kind of gone over what needs to be in the training. So the general requirements of public meetings and proceedings, the procedures to comply, and the penalties. And they do require a certificate. I don't know if you have that or not. I can tell you that if somebody's missed, it's good to do if you don't have one. I think I mentioned this once. I had one newspaper reporter about 15 years ago set a FOA request for the certificates in that town, which I can't remember if they had them or not, but that just reminded me to do it. There's actually something you can just download on the ombudsman page. There's a certificate there, or the city may provide one. Yeah. Okay, that was FOA. Briefly on conflict of interest. Again, I've gone over this with the five of you. You guys are experts on this already, but I'm going to briefly go over it. There's a financial conflicts. That's the kind of conflicts that we are, in some ways, easier to describe. There was a common law financial conflict of interest if you're essentially self-interested, right? So you're voting on something where you would benefit from it, and there's some case law on that, but not a lot for us. So what the legislature did was have a statute in place. So there's a municipal conflict of interest statute that applies to your work and to you as board members. It sets out a black letter conflict for financial conflicts when you're self-interested. It's a pecuniary interest test. And it's shortened as called the 10% test. So this is when you're financially conflicted. When a member is an officer, director, partner, associate, or stockholder of a private corporation, business, or other economic entity, which is the subject of the issue before you, so in other words, the applicant in your case, for some sort of approval, and in which you're directly or indirectly the 10% owner of stock or of the company. So if that is the case, then you're conflicted, and you should step down and not obviously hear that application. I will mention that you are certainly allowed to be an applicant. So there actually is a Maine Supreme Court case on that in the last 10 years out of Wiscasset where someone challenged a board member's ability to bring in their application, and the court said, no, absolutely not. You don't give up your rights to be a regular resident here, voter, but you just have to make sure, obviously, you can't participate. You have to step down and make it clear that you're not at all part of the process of review. So the statute also directs you to avoid the appearance of a conflict of interest. That's a little bit more difficult, right? So you don't meet a black letter test, but there's some sort of appearance. And that could either be a financial, that's something less than 10%. So you're sort of a lesser owner, or you're an employee maybe of a company. Or you have some sort of bias or predisposition, which I'll mention in a minute. That's something in some ways that only you know. But there could be an appearance because, for example, someone in the community knows that you may have been putting on Facebook that you don't like that kind of development, right? Or something like that, or that specific development. And so there could be, at a minimum, an appearance. And so these are the kind of questions you need to ask yourself, really, right? Do you think in light of the points raised and circumstances and situation that you can participate in the proceedings without bias, predisposition, or letting your relationship impact your participation or decision? And will you conduct yourself and base your decision in the proceedings based on solely on the record and based on your best judgment in applying the applicable and relevant standards, right? So in other words, can you be dispassionate and apply the standards without any kind of bias? That's what you have to ask yourself. If the answer is no, you should step down. I'm sorry, if the answer is no, you can continue to serve. But the process for doing that is disclose that, right? That may come up because someone raises it, some member of the public or something, or a fellow board member raises the issue, or you feel the need to disclose it because it's a close enough relationship that you want to disclose the fact that it's someone who you may know, you may have done business with before. And so you would just, I want to just let everyone know, I've done business with this company. I have nothing to do with this particular application. I have no opinion about this application. In my view, I can sit dispassionately without bias. And then what you would do is vote to allow that person to sit or not. That's the process to go through. If the answer to those two questions previously was yes, and that's what I meant to say, then you should step down, right? You should say, I do have a conflict. And it's best for everyone for you to then step down because the consequence is that your action could be voided if challenged in an appeal, yeah.
So I just want to touch, I think we've done a very good job of always disclosing any possible conflicts. I guess I don't think we've done a really great job of doing a formal vote. I mean, now, is that something that do we need a motion to say, I think that, Jim has disclosed this, and I think he should be able to participate, or is that just something the chairman can call and say, and vote to see if, X, Y,
I
Z
think
member-
that is the best practice. I know that it doesn't always happen. But the best practice would be to take a vote, and that way it would show, if challenged, that issue is fully disclosed and in some ways vetted by the members. They heard what that member had to say and they all agreed, right? So that is the best way forward. If you forget to vote, it's the best is that you at least disclose it. So at a minimum, that should happen. You disclose it and you explain why you think you can sit without bias or predisposition. But if you remember, I would say, and then you should also vote to allow or not to allow.
Sure, so that's something we could start to incorporate. So we do talk about it, and we do talk about it with the whole board. And if there's any hesitation or opposition, we would take a vote. I don't think we have gotten to that point yet. I think, generally speaking, I think when we bring up those questions or thoughts or concerns, the board seems to be, we have enough discussion.
Right.
That I think it's clear that the board supports, the member to continue.
And you always ask the applicant, too, if they have any objection.
Yeah.
We do, yeah.
And that's a good practice as well. So sometimes it may, depending on the factual circumstance, I would say, but particularly if there's something that is that may be controversial or that the applicant may have an opinion about, it's always good to essentially ask the applicant because the decision could affect the applicant, right? So if they get an approval, for example, but let's just say in the unlikely position there was some sort of bias that someone's able to prove, right? That decision could be overturned. So it's in that applicant's interest to say, look, maybe they prefer you not to sit.
Sure.
But you guys still get to decide. You could still not, vote to allow somebody.
So is that something that the board must ask the applicant, or is that just sort of a?
I think it's a good
Kind of
practice to do so.
good
Must
practice.
is strong, but I would say if it's disclosed, to say we've heard, board member Clark has disclosed this, appearance, but do you have any concerns with that?
Okay.
If they say no, that's very helpful, right? So.
Well, I think that's to date, I think when we do ask the applicant, I think to your recommendation about voting as well, but I guess that further reinforces the discussion had when we ask the applicant and then they respond without objection, then that seems pretty good, I guess.
Yes, it's good to do.
Okay.
I'm kind of quickly going through these because these are really for councils. There's some, I put them under the conflict of interest, but there's some prohibited appointments in municipal life. None of these really apply to you, other than there could be sometimes, I'd say under the common law, not under a statute that I'm aware of, one, for example, this municipal officer or their spouse may not serve on a board of appeals. That's actually in a statute. There's not a corresponding one for planning boards, but that it may also be something that the city council would take into mind, is to not appoint. There could be a conflict there because the city council, I'm going to get into this very briefly in a minute, has a different role as it relates to planning than you guys do. So that could be what I would call a common law incompatibility of office. The other bias besides prejudice is a familial bias. So that's the other sort of one you should be aware of. If an applicant in front of you is within second cousins inclusive, then that's a family bias, we'd call it. So you should step down. You shouldn't hear those kinds of cases. So consanguinity or affinity within the 6th degree. It's one of those trust and estates first year law school words that I don't use other than that. But it basically means second cousins inclusive. And I've already kind of gone over this. It's always important to remember that you are, before I move on to the final piece, is you're sitting in a quasi-judicial role. And so it's important for the public to obviously have trust in your decision-making. And so that means avoid appearances of conflicts of interest, a bias, predisposition, but also, follow FOA. Don't talk about these applications outside of the meetings. Make sure, don't go do, and I've heard this before, but I'm gonna hit a couple because it's always good to remember, don't do your independent research. That's the hardest one. I do maybe one of these trainings like every other week. That's the hardest one for board members to get because it doesn't feel like, we all like to do our homework, right, in our jobs and everything else, but you're sitting as a quasi-judicial body, and so you've got to receive the information from the applicant and members of the public, and then you process, or staff, and then you process that information so that everyone has that same information. So you shouldn't be going out and doing your own site walks by yourself, or research into the correct, engineering techniques for certain subsurface wastewater systems. That's not your job. If you have questions like that, you ask the applicant or staff to provide that for you so that everyone sees it.
But that's different than our own experiences.
That's right.
Or professions or.
Everyone comes to the table with what you already know. You can't unknow that. That's right.
Sure.
That's why it's. I think it's always a good idea to have a board with people from different backgrounds. You're going to bring that. You can't unknow what you know, but but you should be doing research on that particular application.
Phil?
Yeah.
On the conflict question, because you've addressed, if an applicant is related or you have business connections with an applicant, that seems quite clear. What about if you have a relative or a close family friend or a business associate who shows up as a member of the public and opposing an application? What sort of disclosures would you do there to make sure that the public appreciates and the applicant appreciates that you're not, as a board member, biased because of, members of the public who you're related to?
Yeah,
or
that's a good point, and that's something probably it's harder to see, right, because it's not the applicant themselves. But I think that falls in the category of avoiding the appearance of a conflict, and that includes any kind of bias or predisposition that someone may think you may have. So if that were to occur and a member of the public gets up and speak, you may want to, after that person speaks, or actually during the deliberation phase, note just for the record, I just want to note that a member of the public is, my cousin. I have my own independent thoughts, and I can continue to sit here in a way that's unbiased and without predisposition, but I wanted to just disclose that for everybody. I think that's helpful, and again, helps the public kind of believe in your process.
That's
helpful. Yeah, so that's a good point. Thank you, Jim.
Can we just, as far as the bias or the common law, can somebody continue to serve like on a board if they become an employee of that city? Is that a conflict or?
Not necessarily. So again, there are certain statutory incompatibility of office provisions. I will go back now that you bring it up. So a town manager cannot, I'll just pick that one out, cannot also serve as a council member. That makes obvious sense. They work for the council, or selectmen in this case. Municipal officers can't serve on Board of Appeals. There's a few others. But those are clear because the statute says you can't do it. I can tell you, and I represent a lot of small towns, there are some small towns where some elected officials have other roles in that community, and as long as it's not either a statutory incompatibility office or any kind of common law. And so I'll go back for a second. There was a case, there's a couple cases out there. Sort of the most recent is Callahan versus the city of South Portland. It was an interesting case. The city of South Portland had a prohibition on anyone serving on the city council, any employee sitting on the city council or the school board. It's a municipal school committee. And what the court said is that's okay on the sort of in the same column, right? So in other words, you could prohibit a municipal employee from becoming a city councilor. But the court had a harder time with prohibiting, for example, in this case, a library employee from serving on the school board, where the school board had no supervisory role at all or budget over the library side, which was the municipal side of the town, of the city government. So that's the kind of analysis that goes on. I know of a couple code officers who also sit as select board members in small towns. So there's those kinds of roles where the select board doesn't have really authority over the code officer. So it becomes a kind of authority issue, like who is, because you can't be your own boss, essentially. But that's something for the council here to think about when they're making their appointments, or the city administrator when they're hiring people. Just a couple laws I just wanted to briefly mention. I'm not going to go into a lot of detail today, but a couple laws that you will touch upon from time to time. Last time I was here, I also was not asked to present on these new housing laws, but you may remember I did sort of extemporaneously. That was LD 1890. There's now a new version of that. We're on the third iteration. It was LD 2003, 1890. Now we're LD 2173. That was passed this spring. It's an amendment to those series of land use laws. It was considered a cleanup bill, and it mostly was. Mostly kept LD 1890 in place, but it did make some substantive changes. I'm not going to get into a lot of detail because I understand Emily and city staff are going to give you a longer presentation on that. But this is going to be something that you'll be working with, and it's going to require some amendments to your ordinances. They go into effect July 1, 2027, so the legislature did push out the implementation date, but that's coming right up as you think about how the process works. There's going to be minimum lot size requirements that are different from what you've seen last time, density requirements. I did make some helpful clarifications on sort of what a public water and public sewer requirement is for these density requirements, what the height bonus means for affordable housing projects. So it'll be interesting. I'm not going to get into it. I was just asked to mention it, but I understand you're going to get a more in-depth presentation. A couple other statutes that come into play from time to time in your work is, and again, I'm not going to get into the detail, that these statutes could have its own hour at a minimum. But I've seen some sort of more activity in these areas. So there's a federal law, two federal laws I'm just going to briefly mention. So the Religious Land Use and Institutionalized Persons Act, or LUPA, that's what people call it. It's a federal law that invalidates local land use laws that substantially burdens religious exercise, unless the government can demonstrate a compelling governmental interest for the regulation and it's using the least restrictive means possible to further the compelling interest. So just briefly what that means, substantial burdens, there's 3 additional prohibitions. An equal terms provision, which prohibits governments from imposing or implementing a land use regulation in a manner that treats a religious assembly or institution on less than equal terms with a non-religious assembly or institution. It must be non-discriminatory, your ordinance, and governments cannot impose or implement local land use regulations that totally exclude religious assemblies from its jurisdiction altogether. So you have to provide some places for these assemblies, or unreasonably limits religious assemblies, institutions, or structures within a jurisdiction. So there's not a lot of litigation in that area, but there is some around the country. And so it's again, not something it's just something for you to be aware of. It's really for the council, where in this city is the body that adopts your ordinances. So to keep in mind. I've seen a challenge once. It didn't go very far, so I don't have much to report from it. But that's something you'll come across. The other one that I see more and more of also relates to wireless communications, wireless facilities. There are the major act that you'll hear about is called the Telecommunications Act of 1996. That was the law that essentially was to help promote wireless telecommunications around the country as a federal policy. So it has a shot clock. It requires a 60-day review. It preempts some of the regulation that municipalities can do. So again, you don't see that from federal law a lot, but this is one area that it does. You can't unreasonably discriminate among providers of functionally equivalent services. You can't have an effect that would have the effect of prohibiting the provision of wireless services. So in other words, one of the things you guys may have seen it is there's sometimes analysis that are required because the providers will show why there would not be any service in a particular area if that tower didn't go right there, because that's one of the ways they can comply with this act. So there's that law. That's the sort of general law. I will mention one other thing because I hear this a lot. You can't regulate the placement, construction, and modification of wireless services on the basis of environmental effects of radio frequency emissions. Radio frequency emissions, as long as it complies with the FEC or the federal rules on that. So you'll sometimes see that, but you can't regulate on those bases. There was another act in 2012, and this is where I've seen more activity, quite frankly, called the Spectrum Act. And what it did is it modified that 1996 Act, and it allows, essentially allows almost by right certain changes to existing towers. So they can add up to 10% of the height of the existing structure, or the height of one additional array with certain separation. There's a width and dimensional increase. They can widen existing towers by 20 feet at the base, and they can add additional equipment up to 4 without regulation. So planning departments will sometimes see these applications. These guys know how to apply for these things now. So they'll apply and say, I'm applying under the Spectrum Act. All we're doing is this. We just need essentially an approval. And again, there's a 60-day requirement. There's still some regulation that municipalities can do, and a lot of municipalities do have telecommunications performance standards for towers, setback requirements, those kinds of things. But I just want to point it out because there is a federal overlay on what municipalities can't do. I'll put it that way. Yeah.
So you said on their infrastructure or their existing facilities, and I guess automatically by default, I'm thinking 100, 190, 200-foot tower, right? But a lot of these entities are now starting to do mini towers on utility poles and stuff. Yeah. Does that still fall under that umbrella, or does the town have some enforcement ability to,
there is
when they want to
some,
put it next to the school, the elementary school, let's say? And
right. Yeah, there is still some regulation that the municipalities can do. In terms of location, though, they are limited in terms of if it would have the effect of prohibiting essentially cell access in that community, then you would not be able to say no, right? So, but there may be an alternative to that. So that's part of the analysis. They have to show you the alternatives analysis, why that particular spot is where it has to go. But that's I think it's in almost every ordinance I've read. So that would be part of what an applicant would need to show you. Finally, just because I've had a couple questions, there's been some various reasons for these questions recently, but to what extent do state or federal officials, facilities need to comply with local land use requirements? And so it's an interesting area. So the state zoning law used to say specifically that zoning laws were advisory only for state government. It's now a little more nuanced, and so this is in section 4352. That's the zoning ordinance statute, if you're inclined to look at it. It says a zoning ordinance that's not consistent with a comprehensive plan is advisory with respect to the state, except as provided in the section, a state agency shall comply with a zoning ordinance consistent with a comprehensive plan in seeking to develop any building, parking facility, or publicly owned structure. So it's interesting, they only call out those three that they shall comply. However, the governor can waive those provisions upon a finding. There's 4 standards the governor would have to go through. So the state still can decide, and there may be a statewide interest in having a certain office in a town, and the state could go through a process to exempt themselves from local zoning. There's also certain public utilities that can get exemptions, but they have to go through the PUC. So if they ask the PUC, we need to have an exemption, they can do that. The Maine Turnpike Authority is another entity. It's its own sort of quasi, it is a state agency, but it's got its own standing, and the state Turnpike Authority also does not need to comply. So you'll often see, well, I should say the DOT too, for state highways. So they have plenary authority to put state roads and the highway where they want to put it, quite frankly. And they have eminent domain authority as well. So they still will often use a consultation process with the municipality, but ultimately they'll make a decision that's in the best interest of the state or that agency. That's about it. I go into some detail sometimes more about your roles and responsibilities. I think you guys all know those under your local ordinances. So I'm not going to get into that, but if you guys have any questions, I can answer some. Thank you.
Great, thank you, Phil. Any questions from board members for Phil? Any thoughts? Any thoughts from staff? Questions for Phil while he's here?
All right, well, thanks for
Great.
having me.
Thank you, sir.
Always good to come back.
Thank you, good to see
Okay.
you.
I'm going to disconnect.
And Phil, speaking of the turnpike, how do you like our new exit and on-ramps?
I like it quite a bit, because and I only say that because my son does basketball in the winter. And so were those two facilities, everyone has to go to Saco for basketball in the winter, because you have two facilities. And so that made it a lot easier to get out to that direction where the sports is. So, thank you.
Great, thank you, sir. So with that, I'm going to turn it over to Lauren, and I guess we have staff members with us this evening to go over a few of your city staff process.
Yeah, thank you, Mr. Chair. So we do have staff members with us tonight just to go over the development review process and each of our roles in that process. I'm just going to pass it off, I guess, first of all, to Adam Bliss.
Good evening, everybody. My name is Adam Bliss. I happily serve as your city engineer. I was asked by the team here to give an overview of how we approach applications that come into the city, site plans, subdivisions, things like that. And I certainly can get into the details if we want to go in that direction. I don't think we need to tonight, but there are three main takeaways I'd like for us to take away from what I'm presenting tonight. Number one is we work as a team. Staff here, we have great communication tools. We meet regularly, at least once every 2 weeks, and we go over projects. We go over what is in the review queue, what is forthcoming, things like that. Charles has developed a tracking spreadsheet, which is great because it identifies the project, when it arrived, when comments are due, when it's anticipated to be come before you folks at the planning board level. So that keeps us, that system keeps us on target to take in an application, review it within 14 days is the general time frame. We prepare a memo, provide it to staff with Lauren and Charles and Lisa. They in turn distribute this review memo I'm talking about that I prepare, and they share it with other staff, fire department, police department, wastewater, et cetera. So that's the first takeaway. The second takeaway is, as the city engineer, we work under Public Works, but what that really means is we are looking out for the best interest of other departments, Public Works specifically, because many of these projects, like subdivisions, we're going to most likely accept the infrastructure, the roadways, the sidewalks, the lighting, the stormwater ponds. So we want to make sure that we can access those facilities, we can plow them, we can operate and maintain them over the long term. We're also looking out for the residents that are going to ultimately buy those houses in the subdivisions and build, and give them peace of mind that their trash can be picked up, plowed, the roads can be plowed. So the second takeaway is we apply standards, and we ensure that these applications that come before you comply with local, state, and federal regulations, like stormwater law, erosion and sediment control law, and there's many different traffic, those kinds of things. And then the third takeaway is, I sort of alluded to it, that I am reviewing these applications on behalf of the stakeholders. So that is to say that I am a liaison to other departments, to the residents, to the planning board, you folks, so that we can make this process as efficient as possible, while still making sure that the checks and balances are in place. So those are the three takeaways I wanted to leave with you. And in terms of the review, I mentioned that we are reviewing not only on behalf of the residents and the stakeholders, but also staff, planning staff, and other departments. We all have roles and responsibilities, and I believe that by meeting regularly and talking about these projects, that the chief can rely on me, and the deputy chief can rely on me to make sure that, say, a site or subdivision has proper access for their apparatus to get in and out, that the roads are sufficiently wide and stable, that the turning movements are going to work, say, for their ladder trucks. That's just one of many examples of us reviewing on behalf of other departments. And then there's the wastewater department, Rosalie to my right. She works with Howard, and they have a process. But we also work as a team because, again, a lot of this infrastructure will likely be accepted by the city, and that includes pump stations and force mains and gravity sewers. And again, we want to make sure that we have consistent standards that are being applied to a project. It's so much easier to have, say, a pump station that has a consistent specifications on the valves and the fittings and the pumps, and that they're sized appropriately. It just makes the operation and maintenance of that infrastructure much easier on the people that have to work on it. So that's just another example of working as a team, communicating, and just trying to give you another example of what we look at and how we review things. We look at a lot of things. We look at stormwater. Stormwater has local standards. We have local standards in the ordinance. And then there's also the DEP standards, the Maine, state of Maine DEP standards. The city has delegated review on behalf of the Maine DEP for projects up to a certain threshold. The majority of our projects fall under those thresholds, so we review them in a much more efficient and timely manner than DEP would be able to, only because of, they have many applications to review. So we are taking that burden off of them. We are reviewing the applications. We are applying standards and ensuring compliance with the regulations. So I mentioned, and another one we look at is traffic. Traffic, as you know, is complex. That's when we get into traffic counts. We get into traffic signals and traffic warrants or traffic movement permits. That's another example of things we look at. Public Works looks at that closely, but when we get into the traffic movement permit type thresholds, then we engage a specialist, a traffic engineer, who works with these permits on a daily basis. So I mentioned fire department, wastewater, the police department. We work closely with the police department because, as you know, with traffic comes more conflicts, and so we want to make sure that there's proper signage, there's proper traffic control, and things like that. And then I did mention Public Works, the engineering works under Public Works. We look at, again, infrastructure, stormwater, storm drains, culverts, roads, plowing to make sure that things are going to work for the crews that have to plow. Also solid waste and lighting. So I think I'll take a pause. I could go on, but that would mean going down some rabbit holes, and let's maybe not do that and take a minute to pause. I can hand off, or I can take questions, whatever you folks see fit.
Sure, so maybe a few questions, thoughts real quick. First, we appreciate all your memos and your very thorough review. It's great, it helps the board immensely, so thank you. We know you guys do a tremendous job. And then a couple things. Is there anything the board can do to help your process, or anything that we can, or any specifics that you might look for from the board, or anything that we can do differently, or anything that we can do to help you as well, or make it clear as to what we're looking for, or questions? And then with that, I think the board, a pro and con maybe, is a lot of us have been here for a while, so we've seen a lot of different designs, scenarios, situations. We've seen projects be built, we've seen them be successful and maybe not as successful as we thought they would be. So I think that naturally brings a lot of questions out. I think the board has some good questions, but the board's not part of all of the conversations behind the scenes. And I guess my question is trying to get just a little bit of the conversations that you have with DOT or the developer and a lot of staff. And obviously it would take hours to put together pages of memos and notes, but I don't have a particular instance right this second, but I know the board's had questions in the past of, well, what about this scenario? What about that scenario? Why not this and why not that? And we know there are reasons to your memo and thoughts and notes, but just trying to understand more about it. Does that make sense? There's a lot of rambling there, but.
My answer to your question, it all comes back to communication. And Charles is our quarterback, so to speak. He is, the liaison between you folks and his staff and the rest of us. And communication is important so that I'm communicating to him what I see as potential issues or things that the board should be made aware of that we'll have to work through. Communication is the answer, but that also applies to internally and externally. We live in an age of email communication, which isn't the most efficient. I would say the projects that you see that are more effortless as a result of the communication externally between staff and the agent working for the applicant. And a great example is on a subdivision recently, we had the engineer call me up and say, Adam, can we talk, meet, want to work through these kind of questions, making sure that the design's going in the right direction. And that was fantastic. It just saved a lot of time. And I give a lot of credit to that person for reaching out. So again, communication is the key.
Sure, okay.
Mr. Chair, if I may also,
Sure.
I think just if the board has specific questions, sometimes, staff is always bringing those to engineering. So like if there's a question on sidewalks or something like that that's coming from the board, then that's something that we'll bring to Public Works and then they answer, so.
Sure, and there's, now that we're talking about, there's one on Portland Road, there was a lot of discussion about the turning in, right turn south only, right turn out, and there were a lot of different options there and pedestrian movement through the site, and when that came back to us most recently, there was a lot of clarity on, we looked at this, we looked at that, we ended up here because of, X, and that helped the board immensely. And then another one on Ferry Road with the sidewalks. We talked about a lot of Ferry Road crossings in a few spots, and then it came back and there was good explanation of the discussions had, and this is why we got to here. So I think, like you said, the communication, those are the instances that help immensely, and of course none of us can answer the question of how do you answer the question that I don't know I'm going to ask yet. So that's inevitable, but I know most recently those are the two that do jump out. But of course, I'm just trying to get ahead of questions that we may or may not ask. But I think every application, like you said, every application, I think we all do a better job. And I think that's the key is the communication, like you said, so.
Your example of the right-in, right-out is a great example of the engineer reaching out to staff to try and resolve and work through an identified issue. So credit to them, communication. When we review an application, our first review of that is more high level. It starts at PDRC, typically. So we kind of identify the issues that, hey, beware of traffic, beware of this. Please provide this document or this analysis, just to pick on traffic, something like that. Then when the application comes in, if it's a site plan, we're looking at it from a high level view, and we're not trying to identify every little issue because it'll bog down the process. We try and address the major things that, if they're incorporated early into the design, then future iterations of design will go that much smoother. Things like mail, things like plowing, traffic, things like that are just a few of many examples.
Sure. Well, this is good, thank you. Any other thoughts from board members, questions for Adam? Jeff?
Yes, thank you, Mr. Chair. I too want to echo, I really appreciate the detail in your memos and you guys as a team, right? You guys are all bringing each other up. Every review that we get gets more substantive and has great information in it. I have a hard time, because as I read the ordinance, we talk about the delegated authority on some of the stormwater runoff, and we're supposed to be kind of saying, yeah, it's good, but really we rely on you. You're the engineer, right? We're relying on that information. So when you provide us a super detailed memo, when they all are, I appreciate the technical aspect of that. And you mentioned not bogging down the process, and we'll have some applicants that are before us for 3-4 meetings, and we're kind of getting into some of that stormwater stuff. Do you feel like we leave you in a good position? It's like we'll make a condition of approval that says we approve this, and the final details will be worked out with city staff. Does that make it harder for you oftentimes, or is it, okay, you kind of got the gist of where our concerns were from a board, and then you can take those technical pieces that you truly understand, and you have enough authority where there's not a ton of pushback from the applicant to work as that liaison for all the parties involved. Is it better, or would you like us to try to make some of those a little bit stronger? I guess. I mean, I see how technical you are, and I come from that background, so it's like I want things kind of all lined up. But at the same time, as a board, we can't go through that. We would have these applicants here for 12 meetings.
Yeah.
So are you feeling comfortable that when we put that kind of burden on you and your team, your staff team, saying it's approved with this condition, that these minor details will be worked out by city staff? Has that been working for you?
I think that's in the best interest for all of the stakeholders to leave these final few remaining details to be worked out. There is a balancing act. We can't have, 25 conditions of approval that, details get lost in communication and over time. But in the interest of moving things along, in principle, I agree that's appropriate. And I am comfortable with that. But again, there's a balancing act.
The next thing I had was maybe for phased projects. We've had a couple that have come before us, and maybe capacity to serve or stormwater runoff. Sometimes I think it's been a little challenging where the staff memos weren't kind of clear enough that yes, this is adequate for the entire proposed build-out versus the proposed phase. So, not to pick on Rosalind, but there was one that we talked, 995 Portland Road, I think it was just didn't say, you said capacity to serve, but we didn't know if it was for, or I didn't interpret it, is it for the proposed phase that they're going for now, or is that for both the next phase as well? So anytime you can tie those in, those little details, just the address and capacity for Phase A and proposed Phase B, is helpful. Or protect yourselves and say, hey, we have capacity to serve, but Phase B is for a basic warehouse facility. Any other changes would require additional review. That would help, in my opinion. The other thing I had was maybe your team with in conjunction with the fire department. Oftentimes from Maine Water, we get these kind of very generic, yes, we have capacity to serve. We don't really talk a lot about static pressure in the area. And then, so the applicant has a letter that says they have capacity to serve, but the sprinkler design isn't done yet, right? They haven't done flow tests. And do any of those ever come back or fail? And then they need a sprinkler pump? Can we, as a board of the city, ever get feedback on that to know, hey, this part of town is starting to seem like during firefighting needs could be really detrimental in their capacity to serve? I think that that's helpful.
Mr. Chair, if I may, I just have a comment. Charles and I recently had a meeting with representatives from Maine Water and had more in-depth discussion. And they're going to be invited from now on to any of our pre-construction meetings. So we'll be able to discuss anything that's caught, and that's, after the notice of decision. But still, it's a conversation that we'll be able to have with them at that point. And that's when they've asked to be notified at that point in the project, so.
But in pulling it together, I think this, for us to know that there might be concerns now with firefighting capacity with the type of construction that we're allowing in a certain part of town, I think that's important information to know that the service may not be satisfactory during, your firefighting needs.
Mr. Chair, can I just address this too?
Sure.
So just to piggyback off what Lauren said, it was like a past practice years ago that Maine Water was invited to those pre-con meetings, and a lot of this was handled internally as staff. Certainly, we can make provisions to just kind of share in a broad way, like these areas of the city might have more concerns with pressure. And that's something that we haven't invited Maine Water this evening. We don't have economic development here. We don't have code enforcement, police. So there's a whole other side of the review process you're not necessarily seeing. I just want to make sure that we heard from several of the staff to get us started, and then another training evening we'll invite the other staff, and we can certainly invite Maine Water and CMP and anyone else to kind of address those questions more holistically.
Sure.
Yeah, and I didn't mean it specifically. I'm just saying, because that's something we've always done as a condition of approval. Hey, your project's approved. and then you just have to pass your capacity for the fire department's sprinkler design. And if start having some of those start not being able to meet capacity without extra steps would be helpful as we look at different areas in our community.
Mr. Chair, if I could just
Sure.
maybe put a pin on that point. I do read the capacity letters, and I do look at pressure. I do look at flow rates. And if I see there's a potential issue, I flag it and let the appropriate people resolve it. I don't meddle in it where it is private water utility, but I flag it and hopefully spur people to get together and work through that.
Sure, and I think that's Jeff, what you're getting at is just the overall capacity, and we've never seen a letter that I can remember that hasn't said, no, we don't have the capacity. So I think it's just the reoccurrence and just the reassurance that we always have the capacity, but in the background, all those little pieces and details, are they being tested? Does the water, main water, do they check pressure at any of the fire hydrants? Does the fire department do, how often does that occur? And I know just that added reassurance of just, you don't want it to feel like it's just a letter that just gets issued and check the boxes off, but there's sort of more work going on in the background that substantiates, yes, we do have that capacity, right? Is that?
Well, yeah, but there was one or two that we made a condition of approval as like a preliminary that we asked for data logging. And those just like fell away because there was a lot of neighbors that said, hey, we don't have water, there's not enough water. Once we asked for that data logging, it's like the project went away. And this is just a way of kind of circling back, right? There might be capacity for normal day-to-day operations at these proposed buildings, but if the fire department says, hey, we don't have capacity to serve the sprinkler system that's required without these extra pumps, that gives us a sense, hey, this area of town is really starting to struggle. Let's make a condition that's really stronger to make sure that before they develop it, we have capacity.
Sure, and I think to Emily's point of maybe some other staff
Yeah.
members as well, I have a list for code enforcement on, because you're right, we do hear from residents, and I have water in my basement, I don't have pressure, and how much of that is stemmed from service, city service in the street to, what was constructed and, how their property was built or age, or there's, from that service in the street to the house, that's a big unknown. So I have a list there too, but.
And if I can, Mr. Chair, like these capacity to serve letters, Rosalie's going to share a little bit about what goes into the sewer capacity to serve letter, but they're not rubber stamps by any means. There's a lot of research that goes on in the background, and you can talk to Maine Water directly, and maybe it would be good to invite them out here for another evening when we have training, but, and I know they appreciate it. I know exactly which one planning board member Jeff is talking about here. And Maine Water really appreciated the planning board including that additional study as part of the preliminary conditions of approval on that specific project, because I know which one you're referring to. So do you think we should move to Rosalie next?
Yeah, sure. And by no means not assuming or alluding to we think there's rubber stamps. We know that that more goes into it. And I think the curiosity of the board and just our love for more knowledge, and we don't understand it all. So I think that part is, I don't know, it's probably too much fun for me as well, and maybe Jeff too. I think we think it's fun as well to know all this. We want to know more.
Yeah, and we could talk like all day.
We could, and it's interesting, and yeah. Anyway,
Can you hear me now?
yes.
Well, on that topic of capacity to serve letters, I'm glad that excites you because I was worried it was going to be a little bit boring. But in front of you, I gave each of you a wastewater discharge application. It's called a wastewater discharge application, but it also serves as our official sewer capacity request. And this is something that we have anyone who's interested in connecting to public sewer fill out, specifically for multi-unit developments and industrial and commercial users as well. who plan on connecting to public sewer. And so the purpose of this form is to help us assess the applicant's potential impact on the treatment facility by providing the required information for the Water Resource Recovery Department to establish whether there is capacity to serve the potential user, whether there are appropriate impact fees that need to be issued, any pretreatment requirements for the proposed use, and whether a wastewater discharge permit is needed. And so from this form, I'm going to not go into the detail of each line. I'm just going to give kind of an overview of each section and what specific information that we're looking for. But from the overall form, we're gathering additional information of who the applicant is, where they propose to connect from, how much water they plan on discharging, and what type of wastewater or what potential pollutants might be present in the wastewater. So looking at the form, you can see that it's divided into 4 different sections. There's the contact information, use details, operational details, and wastewater details. And you definitely can go on a field trip with each of these sections. So we're just going to stay on the river and we're not going to go on all the tributaries. So for the contact information, this is important because this gives us a point contact person who we are communicating with. This is very helpful so that if we need any additional reviews or meetings or if we have any follow-up questions, this is the person that we are contacting. And also the address, the physical address of where the applicant plans on connecting is important because this is where we start assessing what sewer infrastructure is in the area and kind of what capacity we have there, piping, pumps, and just kind of looking at the technical design of everything, and also assessing if there's going to be additional sewer infrastructure that needs to be implemented to help the additional flows. So we get a lot from looking at the location. Use details, so this is where we're looking at what type of operations the applicant will be doing on site. A couple different examples of this are food service establishments, so restaurants, daycares, or an automotive facility. Those are just a couple examples of different uses. And then also from this section, very important, we're looking for how much wastewater the applicant plans on using or discharging. And this estimation, it is an estimation. The applicant, if they're having a hard time kind of estimating what they're going to use, Appendix B in Chapter 176 of our sewer ordinance provides a flow chart, which kind of helps them evaluate and estimate what they're going to be discharging in gallons per day of water. And so we look at this section very carefully and we make sure and evaluate this amount of water and make sure that it kind of matches what the use will be, the proposed use. We also have information for multifamily units, and also if a pump station is required, if this section is selected yes, then we have our own separate pump station review that we do, and that's something that we collaborate with Public Works and Adam on. So moving on to the operational details. So if an applicant is not planning on discharging anything other than sanitary sewer, so toilet, shower use, they can stop here and just kind of sign at the bottom and they don't have to fill out the other sections. But for other businesses, we have them fill out the rest of the application to identify if they need any pretreatment equipment. So in operational details, we're looking for grease trap information, specifically for all food serving establishments or any business that has a 3-bay wash sink needs to have a grease trap. For automotive facilities, we're looking at oil water separators, and then other commercial or industrial users might have floor drains, hazardous waste containment equipment, and or they might have a treatment plant on site, so they're treating the wastewater prior to discharging to the Saco Water Resource Recovery Facility. So the next section, the wastewater details. This is where we're looking at and identifying what pollutants might be present in the water. And so we have a couple parameters here, and this is what we're looking at. And there's also in our code, we have, if they need a wastewater discharge application, we have a list of parameters. And if they meet that or exceed that, they might need a wastewater discharge application, or wastewater discharge permit, which helps us monitor their wastewater and their flows. So the wastewater details, also, so this section, as stated in the application, pertains to light industry and heavy industry. Some examples of that, light industry could be food and beverage processing facilities. Heavy industry pertains more to metal plating or coating manufacturing companies or paper pulp manufacturing companies. And yeah, these parameters are our main water quality indicators we assess to determine if an applicant needs to be permitted. So let's see if I missed anything. In closing, when we review wastewater discharge applications and capacity to serve requests, we're looking for accurate flow estimates, clear descriptions of operations so we know exactly what's going on site, identification of potential pollutants, appropriate pretreatment equipment, and infrastructure compatibility and compliance with the city's ordinance. Also, just to mention the sticker that I gave you that says Cease the Grease, that's to promote our fats, oils, and grease program. That's called our FOG program. So any client or applicant that has a grease trap or an oil water separator is put into that program. It's now monitored online, and it's basically just helping the city track these devices to make sure that they're maintained properly, cleaned, and just needing to have those records on file for us to access at any time. So to receive a capacity to serve letter, applicants must ensure that they have filled out this form in its entirety and have addressed all of our inquiries. And if they can't in that moment, they must have a plan to do so. And this doesn't necessarily mean that we're not going to issue them a capacity to serve letter. It just, this is kind of our first step in the process, our planning process, just to make sure that we have all of this initial information put down. Thank you.
Great, thank you. Questions from board members? Rosalie, my only question is what is the largest driving factor to, I guess, to being able to serve the project? Is it gallons per day? Is it, what would be the largest determining factor for sizing a project?
Yes, it's the amount of water that's discharged, I would say. And then I guess when we look at like what is in the wastewater specifically, we have different ways that people can kind of treat or do pre-treatment before discharging to the Saco Water Resource Recovery Facility. I mean, I think our main point is just kind of protecting our system and then also protecting the environment and the waterways. But to answer your question, I think the biggest thing is the amount of water that they're discharging.
Gallons per day.
Gallons per day.
Okay. No, that was a good explanation. I think we appreciate that very much. Thank you. Any other thoughts from board members? Great, thank you.
All right, thank you, Mr. Chair. So I think now we're going to move on to Deputy Chief Matt Duras, just to give us a little bit of insight about the review process from the fire department.
Certainly not as extensive as everybody else's. The fire department's review process does start at access. I know Adam does a great job with turning radiuses for our apparatus, but we want to make sure that any occupied structure, our fire trucks and our ambulances can get to at least 2, if not 3 sides of the building, depending on, everything's fluid, but We want to be able to get around the building and make sure that whether it's a medical emergency or the building's on fire, that we'll have access to be able to mitigate any situation there. We tend to look a lot at fire hydrants these days, not necessarily for capacity, but for access to the building. We want to make sure that fire hydrants are within 1,000 feet of every structure where capable. Obviously, we have a large portion of the city that is not covered under the municipal water system, so that takes on a whole nother element for us. But the areas that are within the municipal water system, fire hydrants are within 1,000 feet of buildings. The rest of the NFPA construction process review is really done by the fire marshal's office in our view, in our eyes, and we work with them. But sprinkler systems, fire alarm systems, and the construction itself under NFPA are permitted by the fire marshals. So we want to have as much input in that process as we possibly can. Not necessarily with design of systems, but location of fire alarm panels, location of sprinkler rooms, location of fire department connections to the sprinkler systems. Anything that has one of those systems, whether a fire alarm system or a sprinkler system, we strive very hard to get a Knox box on the side of the building so we have quick, easy access if something's going wrong inside the building. And generally, any commercial structure throughout the city, we'd like to see a Knox box on as well. So, think anything no. Really, that's the majority of our review. Access, fire hydrants, sprinkler systems, fire alarm systems, and Knox boxes.
Great, thank you. Any thoughts or questions for Deputy Chief Drew Ross? Jeff?
I guess, have there been any reviews? Because we're obviously, we look at the turning movement templates and then we also look at snow storage. We've got different things that we're trying to evaluate on our end as well. Have there been any situations where things have been approved and you kind of look at it 4 or 5 years later and say, oh, it might have been nice if we had done a little bit more on our end to try to protect that? I mean, should we have like a condition? I hate to make too many conditions of approval, but where maybe some tenants are then changing the layout of the parking on the site and it just gets restriped without anybody knowing, and it creates a huge conflict for you. Maybe it's a building you have very frequent, medical response to, and they've changed the parking layout. I'm assuming that staff can go back and say, hey, this was our approved, parking layout plan. You've altered that, and I was just wondering if there was anything that, we could help solidify to continue to make your job easier, because
I can't think of anything off the top of my head. I know we just recently worked with one business down on Saco Island that had a fire lane positioned, and it was a condition of their approval. But trees had grown up and now have blocked our ladder trucks' access where their parking space were. It was a very easy conversation with the property owner or maintenance, and they moved that fire lane area for us with no questions asked. So I don't anticipate many problems like that. I don't know that I've come across any in the year that I've been with the city, so certainly keep it in mind.
So one other question is that, or at least I weigh out, right? Access, and then some places have outside gathering space, whether it be a dining area or a concert venue or mixed use. And, as you point out, you like to have access. And if we put in a request to have, usually it comes from you guys, but like those droppable bollards like they have on the Eastern Trail, are those over time, do those become problematic for you, or have you got a pretty good solution that that's still a great way for you guys to have ready access? Because our society's changing, right? And we want to be protecting our citizens as much as we can. If we see an avenue where there's a gathering space, but it could be a real easy vehicular target, we're going to ask for blocking. And, I know some in the mills were like, oh, well, we can just put granite slabs there, which are great for some applications, but not all, right? We want to make sure if you guys need access, are are those devices working well for you at this point, or are there some that you'd rather us not suggest to applicants?
From my experience, the removable bollards are probably the best option we have on the market today.
Great, thank you. Any other thoughts from board members? Well, this is good. We appreciate you taking time to join us this evening. I think overall, big picture, we appreciate all the review you do, the input, your notes, your memos. And as Adam, you said, the communication part is key. So if there's anything that the board can communicate, to you that you need, or again, anything that you want the board to pay particular attention to, or look at in a particular way, please advise us. We welcome that. We look for that. And vice versa. If there's anything that you need from us, please ask or say. Like you say, the communication, collaborative effort team here. So I think that's how we all feel. So I think we have, like we said earlier, each project, I think we get better and ask more questions, and I think is overall, it's good for the city. But I, of course, don't want to feel like we are burdensome or difficult. I think more curious, I think, is probably the better term. But yeah, any final thoughts, Jeff?
Yeah, I just also wanted to point out, too, I know the fire department, you guys have been very great in the last 9 months or so. Having staff members that have joined us on site walks, that collaboration, having you guys there firsthand is really phenomenal. I like it. I know that you're even doing some of it on the professional side in the codes office and having them there, and it's probably beneficial to you because now you guys get eyes on projects or existing buildings that you may not. So yeah, that sort of collaboration I think is very important. And I think pictures too, like we talked about that turn lane, and Adam's team had sent in a picture, hey, we know of this application that's in another town, this would be a good use for it, and there was an actual picture. So anytime we can incorporate that, I think it helps us all get on the same page, and pictures speak 1,000 words. It just helps with that communication. So thank you all.
Yeah, great, thank you.
I don't want to miss out on Lauren because she had something and Madison had a quick thing.
Of course.
Great, okay. Actually, let's go with Madison first.
Sure. I just wanted to make sure everybody knew I'm the staff liaison for the Historic Preservation Commission. So HPC is responsible for reviewing all exterior alterations, new construction, and demolition within the historic district. Historic district is about 226 properties along Main Street, North Street, Elm Street, Beach, Middle, and School, and Cross. So those are kind of all the intersections of the district. So the HPC reviews any of those projects based on the rehabilitation and visual compatibility standards within the Historic District Ordinance. And then if they meet those standards, the HPC will issue a certificate of appropriateness. So if any projects are coming to the planning board that are also in the historic district, you'll probably see a COA application, approval or denial in the materials that staff provides for you. And then just as a secondary note, the HPC, along with Maine's Historic Preservation Commission, can serve as a advisory review body for any properties that the planning board is reviewing under site plan review, if it is on the National Register or if it's eligible for the National Register. So that's HPC.
Great, thank you.
Sure.
Jeff?
Can we at some point maybe get some feedback from the historic preservation, and because Mr. Saucier talked about some training about the new state laws that are coming out for housing, and we have a very beautiful historic district in Saco. I think it's kind of the charm that draws people here. Can we get a sense of if there is still any protection in our ordinances with what the state's forcing with LD 2003 and LD 2173? Because they're overriding a lot of what people who have come before us for decades since we've had zoning have been trying to build in our community. Is that overriding, overstep, whatever term we're going to use, overreach? Is that go into the historic district as well? Could we possibly have some of these really nice larger lots in our downtown being split for housing and you don't have that protection anymore? So that's just kind of a question of mine. It'd be nice to have a little bit of feedback or awareness before the application comes before us, or it wouldn't even come before us possibly. It might just go right to code office. So maybe Emily could touch base.
I'm just going to say that we're going to spend a long time on this. So we're going to become experts. The Long Range Planning Committee is already starting this process. So at some point soon, in the fall, I believe, these ordinance amendments will come to the planning board and we will spend some time digesting all of this. So great question. We're going to take it back and we will respond to it when we bring forward those updates.
Sure, and I was just going to say maybe Madison can, maybe we can find an opportunity to do a brief presentation on how the board reviews projects and the standards. That might help answer some of your questions and how those, maybe a vacant lot or how new construction works with old construction.
Sure. I'd be happy to. Maybe next time we put together a training, I can provide the standards. We can talk through them. Sure.
Great, thank you. Any other thoughts for Madison? We save the best for last?
Okay, great, I hope so, no. All right, so I'm just gonna give a little overview of the post-approval process. So after development review, after the board has seen a project, a notice of decision is issued. And just to give you a little bit of insight and an idea of what happens from there, there are some pre-construction conditions of approval that are usually associated and issued. So these can be things like a draft road maintenance agreement, Form 1s, draft easements. It could be the plans that need to be signed. A reminder, we have some plans that need to be signed tonight, actually, as well. And so these are all conditions that need to be fulfilled prior to a pre-construction meeting. So those are all things that we're following up on kind of behind the scenes. From there, staff holds a pre-construction meeting, and that's a coordinated meeting between planning, public works, and all of the other departments in the city. Everyone that you see here tonight and others as well, with the development team. And we hold that meeting and we discuss things like inspection requirements, the project timeline for construction and build out. And from there, after the pre-construction meeting is held, we do regular site inspections throughout construction. There are also drawdown requests that are submitted often, and the city processes those. We require cost estimate worksheets to come back to planning. They're then reviewed by Public Works, and we make sure that whatever financial guarantee we're holding on a project covers the work that is required or remaining. So if a project is 50% built out, then we may only hold 50% of the remaining 150% financial guarantee on a project. So from there, we go to project completion and closeout submittals. Those include things like as-built plans or stormwater certifications. There's electrical as-built that we collect usually on most projects. They're not always required, but you know what projects they're required on. They're your conditions. So they're things that we're following up on. And from that point, we go through a staff review process So staff will review the as-built plans, they'll review the electrical as-builts, and just make sure that everything is as required, that stormwater certifications clearly state that stormwater facilities were built to plan or were inspected by a design engineer, things like that. We're just making sure that we have all of the required documentation. And after that, we will draft letters that will release financial guarantees. There's a financial release process. We'll still hold escrow accounts for 30 days after a release, and then finally we'll consider a project closed out at that point. But just giving you a little bit of an idea of what that looks like after the fact. And if you have any questions, I'm happy to answer.
Great, thank you. Yeah, this helps immensely.
Any other questions? Jim?
So, as I understand it, when you're releasing funds, you always have a buffer, just in case something happens on the project that ends up costing more than was expected. So in your example, if it's $150,000 being held, 50% completed, you release 75, but you still have that 25 buffer, and that's consistent with all projects?
Yeah, so just to clarify, financial guarantees are always 150% of the cost of the project. So if the project is for $100,000, we hold $150,000. And then if the work is 50% complete, then we would hold $75,000 still. So yes, there's still that that extra buffer. Yeah, 25% buffer. Yeah, yeah.
Great, thank you. Jeff?
Yes, Mr. Chair. So, two things. I guess part of it playing on Jim's question, maybe can staff relook at that? I've heard of a lot of, developers that might see me on the street and say, geez, Saco is one of the more challenging towns to do business with because of that financial guarantee. And I'm looking at it as a board member going, well, we really want to protect our citizens so we don't have this half-built project, right? So, and, I hear that other communities, it isn't as much, or, you guys as a team are constantly collaborating, and we've noticed it and talked about tonight how everything continues to get better. Maybe you can look at this in-house, and maybe it's a communication thing. Maybe they're not understanding the request for drawdown at stages. I know Charles has mentioned he'd like to kind of help with that, and that's just one of those tidbits. I'm sure you guys probably hear it, but we hear it as well. And one thing that kind of resonates for me being in business, it's like 150%. And that's like a lot of inflation to guarantee that a project's going to be done in a 3-year window. And as a taxpayer, I don't want to be carrying the burden if it's not enough. But maybe in staff, if you could kind of look at that, and is that the most suitable amount? It's obviously problematic and challenging when you hear people going, oh my God, it's so much more expensive to do business in Saco. So I respect, right? We're both trying to protect the community and get projects done, but maybe if that can be reevaluated, or just maybe like you guys generate such great documentation, maybe the request for drawdown being submitted to the applicant at time of approval so they can truly understand what points they can request it would be helpful.
So that is done, but we, as far as documentation ahead of time, but we are looking at this process and whether it remains 150% for everything, but I don't want to go farther in speaking about it this evening. But we are looking at it. It is something that Charles and I have spoken about, and I was actually speaking about it to Joe LaVerrier, and I were speaking about it years ago. So it is on the radar, but right now we are following the ordinance requirement, which is the 150%. At some point in the future, I agree it should be evaluated again, but right now what Lauren's doing follows, like you say, exactly the ordinance process.
So then my second question brings it back to something that I feel like is tasked on us a lot, and over my years on the board, it's like each planner has a little different view, is financial capacity. I feel like sometimes it's disclosed, oh, we don't need to even look at that until final review, or I read the ordinances, every one of our reviews, we're supposed to have proof of financial capacity. And we've had a couple of the minority that will have a really rock solid financial capacity letter. And maybe could we just do a template that would say, hey, if you're coming before us and you're going to submit a plan, we want a lending institution that says, you know, we recognize this plan with a map and lot or an address, and the proposed plan is X number of dollars, and given approval and our relationship with the applicant, we would be willing to, you know, possibly loan them the money. Something that gives us time and place, applicant, and a rough value. And I get it, right? We all know that as everyone works through their details, the cost of construction goes up, and at the final approval, before they get their financial guarantee, everyone will have double-checked and agreed on what a construction cost would be. But I feel like I'm being asked with enforcing an ordinance that oftentimes, oh, well, you know, the bank just says, I know so-and-so, and we'll loan them the money. We don't even know what they're talking about, you know, what project or where they're at. So either can we, maybe, Emily, from, you know, a policy, remove that it's not required in the review until final, or if it is going to be required, before we waste all of the staff time, because you guys all put so much effort into reviewing these, let's make sure the applicant has capacity for the project they're proposing in some sort of like a templated form that met those requirements.
We'll get that clarified. We have templates for financial guarantees. It's a very simple thing to do. We just haven't put it on black and white piece of paper yet, but we can certainly get that clarified and work as a future item on that.
But that's the big thing, right, is you said financial guarantee, which is at the end. That's final construction.
Yeah, I don't
and financial capacity are the two that I feel like either we interchange them and I'm misinterpreting it.
No, my apologies. I said we already have templates for things like other things,
Okay.
like, you know, templates for a cost estimate, templates for the letter format you need to go to the bank with. So it would be very simple, is what I'm saying, to have another template for financial capacity. Sorry to confuse those. It's not intentional.
Great, thank you. Any other thoughts or questions for staff? Any questions for us? Thoughts, concerns, conflicts, disclosures? All right, well, we appreciate everyone joining us this evening. We really do appreciate all your time and effort and work with us on this, so much appreciated. All right, well, thank you. We'll move to our item 10 on our agenda, which is our general correspondences. It looks like we have 3 items from a resident on our general correspondence. Anything to add on that, Lauren, or anything to discuss?
Nothing additional, no.
Okay. And with that, our next item 11, any planning department updates or discussion items?
I think the only thing from the planning department would be that the website is currently under construction. So Charles is working on updating some elements of it, and we should have some new pages up fairly soon. So just wanted to pass that on.
Great, thank you. Our next item 12, any planning board comments? Jeff?
Thank you, Mr. Chair. I guess I'd like to touch base on that public comment that was submitted. I kind of go back and forth on this whole zoning thing, and I feel like, you know, the documents that were submitted today with a legal opinion really seem like it makes sense to me about the expansion of use. And, you know, and it's hard because we only have 3 existing contract zones that were approved or vetted, and each one of them is very different, and I kind of view them differently. I don't know, at some point, do we just have to have like a joint thing with council and a legal and decide where we're going to go with this? Because I feel like oftentimes we're asked to review something that maybe codes should have shut down, or I don't know, I just felt like, you know, obviously we have some citizens that took some time and have worked very diligently and hired an attorney that presented something that's, you know, pretty clear to me in my eyes, that could be going on. And I mean, I just kind of feel like, do we just, it's hard because we can't talk about it if it's an active application, but they're bringing up very valid points that need to be looked at because some of these contract zones continuously come before us. And I think it's clear if you have an underlying now newly permitted use that was a contract zone before, it's kind of a moot point because it's currently permitted. It's when it was a non-conforming use. And I think back to, you know, when Attorney Katsifis gave us his review, it was very thorough. The former city attorney, Mr. Murphy, gave us some about, you know, non-conforming uses that we all know of at different parts of our town and what is defined as an expansion of that. I think that in my mind, there were 3 city attorneys that all kind of correlated with what was presented. And, I mean, do we just let it be because there's not an active case before us and we should be that city staff to be handling it, which makes sense to me. And it makes sense because we're not an enforcement body, right? We've reviewed it, but at the same time, if the question is being asked about the remaining 3 contract zones, every contract zone or former contract zone that comes before us, are we in violation by making those changes? And that's where I get really confused, and I don't know at what point to kind of throw my hands up and say, I don't want to make any decision on any of these 3 at some point. And I know it's a difficult position for all of us, but at the same time, I think we should probably deal with it before, or do we have to, as a board, do we just wait and draw the line when an application does come before us, one of them, I'm going to say, I don't want to move until we get a formal opinion from the city solicitor on this.
Matt? So my take on that is that letter was really written to the city council and the mayor, expressing one attorney's point of view about one of the contract zones. And, you know, we were probably copied on it because we had some dealings with that particular contract zone in the past. But I don't see this as having anything to do with us. I mean, the city council's acted, it's up to the city council to deal with it with the city's attorneys. And back last November, the city council did that. So I certainly appreciate the comments by the citizens, and I read that carefully too. But I think the city's attorneys have a different view on that, and I think we just go with the city council and the city's attorneys, and if those citizens or anyone else wants to litigate the matter further in court, then they will, and we'll all find out what the courts think. But I really don't think this is anything for us, but I appreciate your concern about it, Jeff, because and you've expressed that before. But I really don't think we should get involved at all.
I guess my question, though, comes is, like in all of our trainings, right, where one of the first things we do for every application that comes before us is, do we have the right to review it? And that's where this whole topic is getting to me, is that do we even have the right to review some of these if it were to be a former contract zone? And you're saying that the city council has ruled it, and we're just, and I guess if that's the case, and if that's what I'm missing, that was the determination, and if it comes before us and city staff has vetted it, we have to make a decision, then I guess you're right, I would make that decision. It's hard for me to process as a lay citizen in that regard, because some of the things, I think I was on the board for one of them that we actually approved what would be clearly, you know, what they were discussing about, and I feel like I erred. I feel like I dropped the ball on what my role was.
Well, that's true. If that attorney's opinion is what a court might eventually conclude. And as far as I know, no courts have made a determination on that. So, I appreciate the worry and what our role is, but I think we just take those citizen comments and the citizens' attorney's comments as a point of view, and we take our lead from the city council and the city's attorneys, and we'll let all those people fight it out in court later if they want to,
Well, there's, I think a confusing part to this is one of these larger contract zones encompasses multiple pieces of property. And that's different than maybe another contract zone in another area that encompasses one piece of property. It's a zone, and in one instance, it has multiple pieces of property. So just because there's a vacant property with that zone that has nothing been, that's vacant with no development, doesn't mean that it's all of a sudden new. It was part of the underlying original, I think, contract zone by right, I think we're calling it now. But I think that's the confusing part. There's these multiple unoccupied vacant pieces of property within that zone. That's the part that I think that makes it confusing. That doesn't seem applicable because I think the last few have also met the Portland Road zoning districts, which is, so I read it as well, and Jim, I share Jim's opinion on it as well. I don't know, we have direction from council. I haven't seen any hurdles yet, unless it came to us and didn't meet any of our current zoning, or didn't meet any zoning, they wanted to do something new. That would be a different conversation, but.
Yeah, I mean, I think as a quasi-judicial body, we're waiting for some sort of application or controversy to be in front of us, and there isn't an application in front of us. So there's nothing for us to review, there's nothing for us to decide. I see this as opinion and information, and we don't have the authority to make any sort of rulings at this point because there's no application in front of us.
And specifically on zoning.
But, yeah, you're right.
We're not
I
the
mean,
zoning board of
yeah,
appeals.
There's a difference between an alleged expansion of a contract zone and working within a contract zone that's been set out, and these are different, very different properties.
Mr. Chair, if I can.
Sure.
We have this general correspondence on the agenda. I just want to be cautious because there are members of the public who are interested in hearing more about contract zones, and I wouldn't want anyone to feel like they didn't get an opportunity to hear this discussion, although it is being recorded. So I just wanted to kind of point that out, and it really wasn't an item for this evening, as has been noted.
Sure.
Thank you.
Thank you. All right, any other thoughts or items for planning board comments? All right, well, thank you everyone again for joining us this evening. We much appreciate everyone's time, and we will adjourn at 8 p.m. Thank you.